We are here this morning on the matter of case number 123083, a petition by Derek Schmidt, Attorney General, to determine the validity of Substitute Bill 563, the provisions reapportioning state legislative districts. Would council please state their appearances?
Law firm.
Council. Before we start, I might draw attention to the empty chair. Unfortunately, Justice Rosen has tested positive for COVID, and the court is following isolation guidelines. So he will not be present in the courtroom today. He is listening to the arguments and will participate remotely with the court. And it's something that we've gotten very used to doing over the last 2 years of conferencing cases through remote technology. And that is the way we will be handling the conferencing of this case. But he will participate fully in that and the decision. With that, I would also note that the clock is not working this morning. So I will be keeping track of time. If council have any questions about that, they can let me ask. I doubt that we'll be very rigorous in keeping that today anyway, but rather we'll want to be sure we've exhausted all the questions that the court has. So with that, General Schmidt.
Chief Justice Lugar, may it please the court, with permission, I'd like to reserve 10 minutes to respond at the end.
Brandon, thank you.
Also, Your Honor, I don't believe there's the equivalent of a point of personal privilege in this branch of government, but just very briefly, I might express my particular pleasure to be here today. As you know, this proceeding occurs only very rarely in our state under Article 10. And 10 years ago, it did not occur. Instead, because the legislature failed to enact maps, we were in federal court, not in front of this court. So this is the first time in 20 years this has occurred. It's also the first time on my watch as Attorney General. I've occasionally joked in the past decade that, although long serving, I've failed to do the one and only thing the state constitution expressly requires of me. So I'm delighted to be here today. Your Honors, because this is an unusual proceeding under Article 10, I might take just a very brief moment to express how we, at least, as the petitioner, see our role and see where we are, and make sure that that squares, and if not, invite the court to advise us. Obviously, the 1960s were a decade of great activity in terms of reapportionment litigation with the landmark cases of Baker versus Carr and Reynolds versus Sims. This court decided no fewer than 5 cases during that decade, the run of the 3 Harris versus Shanahan cases and the 2 Harris versus Anderson cases. And I would note that all of those cases were decided in the context of a traditional adversarial proceeding, which is how, of course, matters typically reach the court. In 1974, the voters of the state of Kansas amended our state constitution and created the current process that, despite subsequent amendments on different parts of that article, is still in place today. Which creates the proceeding that we have today. And since then, this court has decided 6 cases in rounds of reapportionment, the 2 in 1979, the House only in 1989, the House and Senate together in a single bill as we are here today in 1992, and the House and Senate again in separate bills in 2002. I say all of that to point out that this court has described the proceeding today as not an adversary proceeding. And so my intention is to present information as the Constitution requires to petition the court to determine the validity of these maps. We obviously have reached the conclusion upon our own review at the Attorney General's office that they ought to be determined valid, and that's reflected in our briefing and will be in my presentation today. But my overarching objective is to do my best to provide the information the court needs to fulfill its duty to determine the validity.
Counsel, do you think there's any difference in the legal standards to be applied to maps before the change you talked about, the adversarial aspect of this and then the non-adversarial aspect?
Justice Biles, I don't know whether to say there's a difference. I do think that this court in the cases since the 1974 amendments has told us what the structure of analysis is in terms of determining what is validity. The Constitution doesn't tell us what it means to be valid. This court has supplied in its past cases the structure of the test, what it looks at. And my intention today was to walk through our assessment of each of those. So I don't know if that's quite the standard, but that's the structure that at least we've gleaned from the court's cases since 1974.
One other matter is what can we consider? I know you refer in some part to the legislative record, but I didn't see a request that we take judicial notice of that. I think it's implied. But within that, there are judicial notice statutes that are written for appellate courts and judicial notice statutes that are written for trial courts. How do we, first of all, are we to take judicial notice? And if so, what are you asking us to take judicial notice of? And then which statute do we do that under?
Well, Your Honor, yes, we would request what I think was implicit, and certainly we would ask you to take judicial notice of the public record, the legislative proceedings on this case. That would include all of the filings made in the course of the legislature's formal proceedings on this case, and of course the bill itself as it made its way through the process, and all of the records that would tend to reflect the manner in which the bill worked its way through the process. I don't know what to tell Your Honor in terms of which statute to look to. Again, our perception is that this is truly a unique proceeding. For example, the Constitution requires, and this court has done in this case, it's invited any member of the public to submit statements. That is obviously quite atypical for a judicial proceeding. There's been no opportunity for adversarial testing of those statements. And so I'm not sure what to tell Your Honor, and I don't believe that the court's prior cases have addressed that issue under an Article 10 proceeding as we are today. I suppose that it's fair to generally characterize it as a fairly lax standard, and I would draw that from the court's suggestion in several of the prior cases that it has a duty to affirmatively inquire into certain matters, even if no litigant has challenged them. So, Your Honor, looking at this court's prior cases, and I would note that in none of those prior cases has the court invalidated any House or Senate maps. We glean the following as the court's approach from those cases, that in looking at whether or not Senate Bill 563, substitute for 563 here, is valid, the court looks first to whether it is procedurally valid, second to whether it is substantively valid, and the substantive analysis has generally, in the court's past cases, broken down into an assessment of substantially equal population, contiguousness, compactness, and communities of interest, and then compliance with Section 2 of the Voting Rights Act. So my intention.
Let me interrupt you there, because my reading, and I'm looking at the NRA House Bill 2620 case in 1979. And there are references there to looking at the structure, the classifications that occur in these in that particular legislation for things like invidious discrimination or arbitrary and capricious stand. I mean, things that we kind of bounce around here quite a bit. Well, it seems to me those issues are a part of this too. Now, I'll grant you that the court's never invalidated on any of those bases, but they do talk about them, and they talk about looking to see whether there's invidious discrimination, arbitrary and capriciousness. So would you include that in the bucket of things we're supposed to be looking at?
Justice Biles, I think with respect to invidious discrimination, that is, at least in my mind, subsumed within the Voting Rights Act analysis. And if Your Honor disagrees that it's subsumed, they are certainly part of the same or closely related analysis.
Well, voting rights is racial, and invidious discrimination can include targeting other citizens, if you will, or groups. And so that's what I'm getting at. I'm just trying to figure out how big of a net we're supposed to throw here.
Your Honor, understanding that, I think the answer is no, although obviously it's ultimately up to the court to decide. Here is what I would suggest to the court. Reading back through the cases since 1979, this court in its various sittings and compositions has made a fairly significant number of expressions in the types of things that concern it, many of which were not presented to the court by the litigants in a particular case. And so, we might often in the shorthand refer to some of those as dicta. I'm not prepared to go so far as to suggest the two that Justice Biles has suggested are dicta, but the court has certainly articulated things in those 6 cases that were not necessarily part of deciding a particular dispute presented to it. I think that's a reflection of the unusual nature of this procedure, where the court has, on its own volition, gone out and explored matters that were not brought to it by the parties. So all of that is just by way of saying, I'm not aware in those cases of the court's decisions turning on any analysis of the 2 factors that Justice Biles has suggested. And I wouldn't suggest that we look at those, at least outside the racial context. Obviously, if the court wants to, we're happy to present whatever information the court wants to look at.
Well, I mean, let me push back on that then, because in that 1979 case, I can pull sentences out, and I did this yesterday, where they looked at the invidious discrimination issue as it related to KU students, how the Lawrence University students population was taken care of. And then they've kind of got some broad language here. Let me just quote you this one that stood out to me. We have discovered no invidious discrimination against any group of the state's citizens which would impermissibly impair their constitutionally protected right to vote. So when I read that, it seems to me that the court has taken that affirmative duty you're talking about, looked at these classifications and said, there's nothing to see here. So, I mean, it seems like it's part of the analytical process. And so that's why I'm asking the question.
Yeah, and Justice Biles, I certainly understand how you would draw that conclusion reading the case. And I don't know that I can necessarily disagree with it. In the 1979 case that you reference, my recollection is there were students who had appeared or at least filed and presented their point of view. And so I surmised that the court felt a necessity or a propriety in responding to something that one of the litigants had raised. And that's why it made that comment. I suppose, if we were to unpack that more, if we'd been here in 1979, speculating by looking back, I suppose one of the issues that would have been challenged or would have been for the court to consider is what are those classifications other than the ones that we know are protected by law, such as racial classifications. Is being a student a classification that provides some sort of legal status that the court needs to review? Being a rural individual, is being, fill in the blank, and those issues were never, to my knowledge, probed by the court. You certainly can't. I couldn't conclude that they were in reading the court's decision. So
let me ask a follow-up to that. What is the Attorney General's position, or let me rephrase that. How would you describe the relationship between discrimination and the constitutional right to vote? Because as Justice Biles read, that's the constitutional clause which this court has looked to when talking about discrimination or invidious discrimination. And I'm trying to figure out how those two go together.
Justice Steele, there's not much to, I think, discern from this court's prior cases under Article 10 on that. Justice Biles suggests one example, but it's not been well fleshed out that we could tell.
Well, let's just think in the abstract then. How would or could a state legislature discriminate against a citizen with respect to their right to vote? Other than, I suppose, just saying they can't vote. Is there any other way that a citizen could be discriminated against?
Yes, Your Honor, there certainly is. For example, the fundamental purpose of redistricting is commonly referred to as the one person, one vote principle. It would certainly be discriminatory against citizens to draw districts that are wildly different in size or to fail to correct a size discrepancy.
So malapportionment.
Absolutely.
Which is to say, making districts with wildly different numbers of voters.
Yes.
Could discriminate against that just kind of discrimination could impact a citizen's right to vote.
I think it could.
Is there any other kind of legislative action that would discriminate against a person's right to vote?
Your Honor, I think that brings us back to this court's suggestion previously that the Voting Rights Act, Section 2, is an area that the court looks to. Certainly, there's a long history of litigation regarding racial discrimination, not only in voting, but in other matters.
So
And
that's the Voting Rights Act, but
Yes.
I'm specifically concerned with the constitutional right to vote. It's not the same as the Voting Rights Act. Would you agree?
I would agree, although I would also make what I think is the obvious point that the Voting Rights Act was adopted by Congress for the purpose of protecting the right to vote. And so Congress made certain.
It may
determinations
provide
there.
additional protections beyond the constitutional protections.
Perhaps, yes. I think, Your Honor, I mean, I wouldn't rule out that there
I guess
couldn't
what
be another
I'm sorry
category
to
that's not
interrupt.
obvious
What
to
I'm
what it
driving at
is.
is if the legislature puts a voter in a district they don't want to be in, and that citizen has the full and equal opportunity to vote, and their vote counts just as much as every other citizen's, is there any way they could have been discriminated against?
I think, Your Honor, not as a matter of law, not as a matter that would invite appropriately.
Not under the
remedy from this-
constitutional right to vote, I guess is what I'm saying.
Absent any further questions from the court at this point, my intention is to proceed as I just described. So, Your Honor, the first prong of this court's analysis that it articulated the cases previous is to look at the procedural validity of the law. Unless the court has questions or concerns, I won't take time walking through the procedural manner in which Senate Bill Substitute for 563 became law. It's set out in our briefs. I'm not aware of any improprieties or irregularities in that procedure by which the bill became a law. I would make several points because some matters related to this subject have been raised both by the intervener and also by some of the folks who filed comments with the court. As we read the court's cases on the procedural prong of the test, we at least read it to be literally an examination of the correct manner in which a bill became a law. That is to say, the procedural steps were not skipped, that the bill was properly enacted by law, which of course is the requirement in Article 10. I know that Intervenors Council suggested in their briefing that perhaps that's sort of renders the whole prong nugatory, and I would disagree with that. I think there's actually a very good and logical reason this court would look at those basics in this context in a way, and it has meaning beyond the ordinary, and that is this, that because of the strict timelines and the finality of judgment under Article 10, that if a procedural irregularity that would ordinarily be fatal to the enactment of a statute, in this case, the apportionment statute, were not discovered in the initial briefing, wasn't for any reason spotted by the litigants, brought to the court's attention, the court didn't identify it. Once the court has entered judgment under Article 10, the court's judgment is supposed to be final for 10 years. And so the opportunity to subsequently, through other litigation, test the procedural validity, the basics, bicameralism and presentment, for example, would at least be very difficult. It would present other issues, testing finality versus otherwise. And in looking back at some of the court's older cases, that actually happened in the reapportionment context. It was, I believe, the second Shanahan case. It was in 1963, where the court invalidated a reapportionment act for, I believe, the state Senate, and did so despite, at least as I understand the court's decision, all of the parties in front of the court urging it not to do so. Instead, what had happened was an error in engrossing the bill. I believe it was the city of Leawood was inadvertently left out of the final version of the bill. And so not only was Leawood left without a Senate district, but the bill that had passed the legislature was not identical to the bill that was signed into law by the governor, which does happen from time to time in various contexts. The parties had urged the court to simply supply the remedy and to put Leawood into one box or another, one district or another. And the court declined to do so and instead struck down the statute as unconstitutional because it wasn't constitutionally enacted in accordance with the normal procedures. And it would seem to us logical that that would be why the court looks to the basic procedures as a first prong of its analysis here in light of Article 10 now saying your judgment's final and presenting difficulties in subsequently testing any of those errors that might be presented. Secondly, with respect to procedure, so that's our basic position, and we think that from our vantage point appears to resolve the inquiry, but we would note, we're aware that a number of folks who complained in the context about some of the district maps that are in front of you today have suggested a variety of other what they view as deficiencies, and without expressing a substantive view on that, we can do that later if necessary. But they point to things like the nature of the so-called listening tour that the legislature conducted early, the speed with which the legislature acted, their preferences on communities of interest and that sort of thing. And I would suggest, only as a general matter from a procedural standpoint, those are not things that this court has ever considered procedural defects worthy of invalidating a map. And in fact, we found it interesting in the 1992
Attorney
case.
General, may I interrupt?
Of course.
I don't want to run out of time, but could we briefly move to the substantive part?
Of course.
Thank you. And then if someone has a question on that.
Please. Your Honor, agreeable if I start with the equal population piece of the three that we've discerned from the courts on the substantive analysis? Very well.
And before you move on to that, and I'm sorry to interrupt, I just do have a question on you're correct in historically how our court has viewed compliance with the procedural requirements. But would you agree that that evidence that isn't strictly about constitutional or statutory compliance with the rules of making law can still be probative of the substantive issues, for example, pretext?
I think, Justice Wall, I think that's how this court has typically treated it. For example, when we get to the substantive point here in a moment with respect to contiguity, communities of interest, which are difficult to define, compactness, which is difficult to define. I think the court has suggested in some of its prior cases that perhaps those are not in and of themselves errors that require a judicial remedy, but they might be an invitation to the court to look further in some of those cases.
Thank you.
With respect to the substantive issues, then, Your Honor, substantially equal population, compact, contiguous, and communities of interest, and then Voting Rights Act analysis perhaps expanded if Your Honors prefer.
So let me ask you what you've just mentioned, kind of go to the guidelines, right? I mean, even though it's in our past case law also, it is the guidelines and criteria for the 2022 Kansas congressional and state legislative redistricting, right? They kind of mirror that.
I'm sorry, Your Honor. I don't
Okay, so there
understand.
were guidelines.
Yes.
That are in Appendix A, and those guidelines kind of mirror our past case law or not?
I think in part, Your Honor. For example, I think that there are 4 guidelines for state redistricting.
Right.
The first one generally reflects the manner in which redistricting has been done, and this court has accepted. The second certainly reflects not only your past case law, but the fundamental rule of equal
Right.
population. The third reflects not only the Voting Rights Act issue, but any racial discrimination that would be inappropriate. And then the fourth guideline, which is the one that has engendered the most discussion,
Right.
it tends to reflect, I would characterize them as customary practices for redistricting. I wouldn't characterize them as judicial commands. I don't think that would be accurate. I do think this court has discussed several of them in the past, but it is, I suppose, something of a chicken and egg argument. At least our read of the case law is that the court has discussed those matters because there were issues that the legislature chose to look at and that different objectors or litigants had raised. As opposed to the other way around, as in the first 3 guidelines where the court made a decision on what the law is and the guidelines merely reflect that almost as an ease of reference. I would also on the...
Those are basically the standards that we use for determining validity?
No, I wouldn't, Your Honor. I think the guidelines and their meaning and their role, I suspect, will be of significant interest to the court. I know it is to a number of the folks that filed objections. We view the guidelines as exactly what the name implies. They are guidelines internally that the legislature has chosen to use to guide its work on redistricting.
So what exactly should we use as a standard to fulfill our constitutional requirement to determine the validity?
Yeah, Your Honor, I think that I think less is more. And I think that that is reflected in what the court has so far elected to look to in its prior cases since 1974. So certainly those things that are constitutionally required or required by statute, the court has expressed this previously as looking to the constitutional violations of the Constitution, violations of statute, or violations of legislative rules. If we were actually litigating that, we might want to unpack that a bit and suggest perhaps the constitutional inquiry ought to be the outer boundary, but in any event, I don't think it's necessary to decide that here. I think that's it. To the extent the guidelines go beyond that, I don't think that there are judicial remedies appropriate for the legislature making a decision that may be different from the decision that a few legislators made in adopting these guidelines. By the way, they weren't adopted by
I'm not
your
talking
house.
about the guide. You said the guidelines are guidelines. And so, I understand that, what you said. But I'm saying we are required by the Constitution to determine the validity. And my question is, what is the standard that we use specifically to determine validity? Should we use what we've used in prior case law to determine the validity? What is the standard for validity?
I think, Your Honor, the ultimate standard that's reflected in the roughly equal population and the Invidious Discrimination and Voting Rights Act, to the extent it applies to racial groups of citizens. The ultimate standard is whether the enactment complies with constitutional requirements.
So it's basically just one person, one vote?
I think so, as well as
okay.
looking at, as I said, the Voting Rights Act requirements, application, compliance with federal law.
But when they put in this duty for us to determine the validity of the Reapportionment Act, the Voting Right Act was not passed yet, right?
Your Honor, I believe it was, although it hadn't been amended yet. I believe it was passed in the 60s. The constitutional amendment was adopted in 74, and then the Voting Rights Act, I think, was updated in 1982, but I certainly want to double check that
But the
latter.
word validity in the Constitution predates all of that. I mean, the word validity appears in all the other iterations of, I guess it's Article 10. So that's kind of gets
I
to
understand.
the same point here, that this undefined word, which is the problem with that, undefined word's been around for a long time.
I understand the question, at least I think I do, Your Honor. So it is certainly true that the undefined word is a bit of a challenge in all of these cases and has been for quite some time. Going back to where I opened suggesting the 1960s were a very active time in terms of voting rights litigation, both federally and in terms of this court. Certainly the court's case law, this court's case law uses the term valid or validity with some frequency, probably for the reasons just described. But, we know a lot more today than we did then. We know what the 14th Amendment requires, for example, in terms of one person, one vote. We know some of the limitations on what's commonly called racial gerrymandering, which is reflected in federal law. So I think it is reasonable to conclude that the test for validity is whether there is a violation of constitutional law or whether there is a violation of statute, which I would think typically would be federal statute because of the supremacy relationship. I think that's fair. And Your Honors, to go, it's not unusual. The volume is a bit unusual this time. I think we have 56 people who filed statements with the court plus the one intervener. So 57 folks who expressed their views on this, and the majority are dissatisfied. A few were satisfied. But the concept that there is always somebody unhappy when the music stops and the new districts are drawn is certainly not foreign either to this court or to the legislature. It happens every time there is a reapportionment. And so I wouldn't recommend that the court sort of post hoc decide that validity means something other than or beyond what its cases have pretty clearly suggested before.
Let me
Otherwise,
jump
the
in.
legislature was shooting in the dark.
Counsel, let me jump in and try to pin you down a little bit more on just what you're talking about, which is, and I think Justice Standards is probing this as well, trying to discern what is our standard, looking at our prior cases, which are, a lot of the lingo is reflected in the guidelines. But I'd just like to kind of go through and ask you if these are constitutionally required. So do you think that compact districts are constitutionally required?
No, Your Honor, I don't.
Okay, what about preserving the integrity of existing political subdivisions? Is that constitutionally required?
No, Justice Stegall, I don't believe it is.
What about recognizing communities of interest. Is that constitutionally required?
It is not, Your Honor. The only thing I would say, except to the extent it might implicate statutory obligations such as Voting Rights Act.
So we know that the legislature cannot discriminate on the basis of race.
Right. So no, I don't think anything further than that is constitutionally required there.
What about avoiding contests between incumbents whenever possible? Is that constitutionally required?
Certainly not. This court has recognized and approved the validity of maps in the past that have been
So
incumbents.
to the extent our prior cases talk about any of those things as standards, your position would be that that's really irrelevant to the question before us, which is validity.
Yes, Your Honor.
Well, but our case law has not said it's irrelevant. Several cases that have indicated, we look at, which was Justice Wall's question, compactness, contiguity, and have said that the lack of that can be an indication of mischief, of partisan gerrymandering. And that's where I keep circling back to my invidious discrimination notion. Then the court kind of says, well, there might be mischief because it's not compact. It doesn't mean it's unconstitutional because it's not compact. It's just evidence of maybe something that could be unconstitutional or illegal. And so I want to make sure that we're not, I don't think it's irrelevant. I guess maybe I'm arguing with my colleague here rather than you, but that's the way I'm reading these cases. Now, if you read them differently, I'm happy to hear how you're looking at it. But like I say, to me, it gets back to Justice Wall's question that the lack of compactness, for example, might mean there's something going on, and look a little deeper.
Justice Biles, I want to express a view on the use of the term irrelevant. I understand, I understand that dynamic, but my answer to Justice Wall remains the same as it was when I answered him. The court's cases have suggested that things such as some of the factors, though not exclusively those in the guidelines, can be cause for the court to look further. But I do think the question then becomes, what is the court looking further for? And that takes me back to my answer to Justice Stegall. I think ultimately what the court is looking for is whether this enactment of law, like any enactment of law, is invalid because it violates a constitution, federal or state, or because it violates another controlling statute such as the Voting Rights Act.
So you just said something that is going to have a lot of importance as this day goes forward, which is federal or state constitution. Is it your view that the Constitution of the state of Kansas provides different kinds of standards or protections than the federal Constitution in the context of redistricting?
Your Honor, obviously there will be, I expect, significant discussion on that issue this afternoon in the congressional maps case. I think it is, without arguing what we're going to argue this afternoon, I would say this and hope it's responsive. Obviously, the Kansas Constitution says something about state redistricting because we have Article 10. It is entirely silent on congressional redistricting.
And I'll just cut you off because I do think it's very relevant to this case because at least as I read our prior case law, this court has tended to look to the federal Constitution in determining validity. And obviously we're determining validity under the state constitution, but we've looked to federal constitutional law as well as congressional enactments. We haven't, at least as I read the cases, spoken clearly about any particular standard, substantive standard that might arise from the Kansas Constitution. Can you talk about that? Do you think there is any substantive standard that is different from what we have traditionally applied arising under federal law?
Justice Stegall, I read the cases the same way. And I think that, I think the answer as we stand here today is no. I think the answer as we stand here today is no. And to the extent that it is possible, which is an argument for this afternoon, but to the extent that it is possible for there to be a different standard in state constitutional law, that would be reflected in an enactment in the state constitution. And in any event, I would think there is more running room in the state maps than there would be in federal maps.
But in this case that we're talking about this morning, there is at least an articulable standard to apply for us to determine validity, correct?
Well, I think, Your Honor, the standard is in fact validity. That's the constitutional language. And as we've been discussing, unless I'm misunderstanding the question, I read the court's past practice, and I would suggest it ought to remain its practice that validity in this context means compliance with constitutional law and compliance with applicable statutory law.
That would include probably Section 2, maybe Section 1 of the Kansas Constitution, or to equal protection.
I don't think so, Your Honor. There's been no suggestion that I'm aware of in any of this court's prior state redistricting cases, at least not since 1974, that those matters, those provisions apply. And I don't think the court ought to find one now when in the last 6
Your
rounds.
position
did
is
not.
that validity depends on, it sounds like what you're saying is validity only depends on 2 things, the Constitution and the Federal Voting Rights Act and nothing else. Then why wouldn't we look to our Constitution to determine validity?
Well, Your Honor, I think you would look to our Constitution, but I think that the 4 corners of what our Constitution says about validity was adopted in Article 10. Our Constitution speaks expressly to what this court does. This court has drawn a procedural requirement out of validity from Article 10.
Right, but the substantive validity, I thought you said earlier that we look to constitutional standards,
Yes, that's certainly true.
equal protections in our Constitution.
Certainly equal protections in our Constitution, Your Honor, but this court has historically in this context looked at the federal case law and has applied what appears to be the federal Constitution in terms of equal protection in the state cases under an Article 10 proceeding. And we wouldn't suggest the court depart from that at this point. Certainly not
Are you
post
just
hoc.
saying what this court, I think, has said often, which is the state equal protection clauses are contiguous with the federal equal protection guarantees? They protect the same interests.
Yes, Your Honor.
So we are applying both the federal and the state constitutions. It's just that it's an identical standard, at least when it comes to equal protection.
I'd certainly leave it to the court whether you're applying both or only one, but I think the federal standard is the standard that's applicable and you get there under the federal Constitution.
Is the wording different in the federal Constitution than it is?
Your Honor knows they are somewhat distinct. Doesn't change the court's general reading, recognizing there have been some recent cases to the contrary, that the court has generally and historically interpreted them the same, and particularly in the state redistricting context, where the voters recently in 1974 passed judgment on this most recent Article 10 procedure and standard of validity. Certainly that's what the voters would have thought in 1974 when they adopted the procedure. They wouldn't have thought that the court was going to look elsewhere.
The voters would have thought we wouldn't look to the Kansas Constitution?
Court never had prior to that in this context, Your Honor.
I thought that it was Stovall 1 in 2002 that said, we're going to go ahead and apply federal precedent because the Kansas Constitution doesn't define valid. So before 2002, didn't we look to the state constitution?
Your Honor, if Your Honor has a reference, I'd certainly look at it. I am not aware as we stand here of this court applying in the state redistricting context, certainly since 1974, Section 1 or 2 or other provisions of the state constitution.
Regardless of what the president has said, why would it make any sense for us to ignore our own Constitution? If it has developed in a way, if our case law under our Constitution has developed in a way that is different from federal law on this point.
Well, certainly I'm not aware, Your Honor, that this court has suggested that that's a direction it's headed. and in the context of state legislative redistricting. And, perhaps backing up, I'm not trying to avoid the question, I'm trying to answer. The legislature couldn't know what it didn't know when it did reapportionment this year. It had to rely upon what this court had previously suggested was the appropriate law to apply in whatever determinations it made. As I just suggested, I'm not aware, at least, of the court having suggested what Your Honor's asking me about. And so at the end of the day, it would be difficult indeed to pass judgment on these maps if there was no way for the legislature to have known what standards the court was going to hold them to at the time they enacted the maps. Particularly under the strict timelines that Article 10 requires of all of us who are participating and the reality of primary coming.
Would you agree that Kansas Bill of Rights Section 2 is worded in a way that has no real parallel in the United States Constitution Bill of Rights?
Chief Justice Lukert, I certainly would agree, laying them side by side, there are wording differences, as I just acknowledged to Justice Stanton. I do think, however, Justice Stegall is correct that this court has historically, and I acknowledge some recent exceptions, interpreted them to mean the same. Your Honors, I'm happy to continue to walk through my proposed structure to answer further questions or to sit down as the court would prefer. What would be most greatest assistance to the court?
I have,
go
go ahead, Justice Stevens.
I was just going to try to summarize my understanding of your position, and then you can correct me in any parts that are wrong. As I understand your arguments, you say we look at basically four things and then we stop. First is whether these maps were passed according to proper procedure. Second, whether they treat individuals differently on account of race. Third, whether or not they comply with the Federal Voting Rights Act. And finally, whether or not they comply with the principle of one person, one vote.
Yes, Justice Stegall.
Are there any other standards which we should apply from your point of view? I haven't heard you articulate any, just those four.
Your Honor, I think those subsume everything else that might have been suggested along the way.
And on that point of racial discrimination, I'd like to just for a reaction and to, if I group together several of the comments, I think League of Women Voters, Loud Light, Kansas Fair Maps, and some of the individuals, some of the constituents that make up Kansas Fair Maps and their comments that were attached to that, as well as some of the individuals who commented, seem to focus on two things and many of them connect the two. And one is that there seems to be an extraordinarily large number of splitting of VTDs in precincts, counties, cities, et cetera, much more so than seemed to be necessary from a neutral standpoint, according to the comments. And second, that they have a high impact on racial and ethnic minorities. And I may not have an exhaustive list, but the list I made included dilution in Wichita, Sedgwick County of Hispanic voters, and primarily but also the Asian community, Olathe, Leavenworth, Topeka, Emporia, Newton, North Newton, Junction City, Fort Riley. And there may be others, but those were the ones I listed. Do you have a general response to how we deal with those comments, how we look at them, and then also whether they do impact the validity of the redistricting?
So, Your Honor, with respect to the splitting of I believe VTDs is the jargon of precincts and townships, I think is pretty close to the English, but nonetheless, the splitting of those. I can tell you I made inquiry on that. I don't know what the court's going to want to do with it, because it was an inquiry I made of folks that worked on the maps. So I'm happy to share with you what I think I know about that, but I can't offer anything further on that. After those comments were filed, I obviously noticed that same suggestion, and the response was that because the maps were court drawn last time in 2012, which of course they were drawn by a federal court, the court was respectfully ill-equipped, I think the court said that, to account for almost anything other than strict numbers or keeping BTDs together. And so the way it was described to me was that the vast majority of the additional VTTs that are broken were part of a smoothing, that not of population, but just of geography, suggestions that it makes no sense to have a neighborhood divided, or it makes no sense to have a district line that used to follow a river but doesn't follow a river anymore because that's not where it was drawn 10 years ago. And so the precincts were updated to reflect the actual maps. I can't attest to that. I can't point you to anything in the record. I can only tell you that we did make inquiry because we noticed the same thing. And because of the procedure that we're all under here, that suggestion wasn't brought forward until it was too late for anybody else to intervene or file comments or anything else. So other than our general response, which you have in front of us.
And getting away from your discomfort about the record and evidence and that kind of thing, but let's just take, generally speaking, the idea of smoothing out the geography or the contiguity or the compactness of that kind of thing. Those are good things, aren't they, to try to do?
I think generally, yes, Your Honor, yes.
So not doing them would be a negative thing, right?
I think as a general matter, I think, there's suggestions in the case law. There's, as Your Honor is well aware, there's a line of cases that suggest that when you have a court-drawn map, as we did 10 years ago, that the population deviation should be less than is allowed for a legislatively drawn map. And the rationale for that, as I understand it, is the court is ill-equipped and generally doesn't take into account communities of interest, local preferences, all of the types of geography, all of that type of stuff. Whereas legislators presumably do, certainly are capable to and are equipped to, and therefore should have a little more play in the joints, as the phrase from one of the cases suggests, to do so. So that implies that these are good things, and that's reflected in the guidelines that the legislature presumably thought they were good things. They put them in. With respect to the second part of your question, Chief Justice Lukert, there were lots of particulars pointed to in the various filings. I spotted the same ones that you did. We took a look at them generally. I don't have in front of me and wouldn't propose to sort of walk through them one by one, but here's what we did do, and perhaps it'll be helpful to the court. It was to us as we evaluated. As we look through the various suggestions on this subject in the different geographical areas around the state, generally speaking, the numbers in terms of shifting populations of minority voters we didn't identify any that were dramatic. I'm sure some of our friends who are critiquing will characterize it differently, but they all looked to us like mathematically they were pretty close. It wasn't a dramatic swing. So what we did for purposes of being here today, anticipating this might come up, we went through and looked at several specific districts that this court in the past has looked to in its cases, suggesting, I think especially in the 2002 cases, suggesting that because of large minority populations historically and still today, the numbers haven't changed on at least those, that the court would take particular look at them. So we did do that, and I can call those to the court's attention to try to illustrate the numbers that generally assuaged our concern, at least as we were looking at it. One is Senate District 4, that is in Wyandotte County. Looking at the map packet, which of course is the data that the legislature had in front of them, that includes this data, shows talking about voting age population, not total population, but voting age population, shows the African-American population at 34.1%, which is up slightly from 33.6 in the court drawn map from last time. and the Hispanic population at 29.2%, down slightly from 29.8%. So those numbers, we at least didn't find troubling. A second district that the court has looked at historically is Senate District 29, which is in Wichita. Again, the African-American voting age population under these maps is 26.2%, which is up slightly, a little more than 4, but still, we didn't think it was dramatic. Up from 24.3%, and the Hispanic population was 22%, down, I would characterize slightly, from 23.8%. Those two districts in particular are ones the court has focused on, I think, at least twice before in redistricting, which is why we took a look at them. I won't read the numbers, unless you want. The court can certainly look them up, but we also took a look at House District 34, House District 35, House District 84, and House District 89. For the same reasons, the court had identified those in previous cases as having particular minority populations that would cause additional looks. And again, none of those changes, they're all within that 1 to 2 point range. None of them struck us as particularly concerning, certainly not from a statutory or constitutional standpoint. So the other that I would say, because the court historically hasn't identified all of the different districts that the folks who filed this time did, because I identified a lot this time to take a look at. So again, just by way of illustration, we took a look at the testimony that was filed by the chair of or the executive director of the Kansas African American Affairs Commission and the Latin American Affairs Commission, filed on behalf of both groups. They specifically pointed to Olathe districts. And so we took a look at those. Those were also included in the other filings that you mentioned. And again, the numbers didn't strike us as particularly worrisome from a legal standpoint. Senate District 9, which I know is for other reasons of interest to our friends on the other side, Senate District 9, the African American voting age population is 3.2%, up slightly from 3.1% under the court drawn maps from last time. And the Hispanic population is 9.2%, up from 6.4%. Percentage-wise, it's a bigger increase, but it's still 3 points. It's not a dramatic change in the numbers of folks. At least that's how it struck us. That was actually the biggest change of any of the 3 Olathe districts that were brought to our attention by the folks I just described. The other is Senate District 23, African-American 6.2%, down from 6.5, Hispanic 13.2%, up from 12. And Senate District 37, African-American 4.3, down from 4.9, and Hispanic 10.2, down from 12.5. So I just suggest, if the court goes through and looks at the numbers that were brought to its attention by those filers, and Your Honor mentioned 3 filers, I think they're actually all kind of the same, because I think 2 are members of the first, but in any event, I think the court will find, at least generally, that's kind of the numbers, the ranges we're talking about in all of those suggestions, none of which it might suggest a preference, but it doesn't suggest a violation of law, at least not that we're aware of. And therefore, when we go to the validity of the maps.
I would agree in my review that that's generally true, but there are a few outliers that are somewhat dramatic, I guess I would say. One example, the one that pops up first, because it's the third grouping on the Senate, is what was District 19 that changed to 13, that went from a 74% white to an 88% white, and then 6% drop in the Black population. Each of the different categories, except for Asian Hawaiian, and drop fairly significantly. And there are a few other, but not many. But I guess that's not surprising, given how few districts probably have that kind of diversity, really. And I think the argument is really more that we have historical fracturing of those districts. And so the fact that they remain a steady population percentage doesn't really answer the question of whether we've had that historical fracturing that is discriminating against those ethnic populations. Do we have anything? I mean, there's some troubling things here, but what do we do given the limitations of this proceeding, and how do we move forward? And
Yeah, I think, Your Honor, new Senate District 19, I think you used as the example, and, you know, certainly it is one that has, boundaries have changed more than most in terms of last map to this map. I don't know that I have much to offer the court on sort of the why on that. I don't. The obvious, we obviously didn't draw the maps, and I don't know entirely, you know, the nature of the decisions that went into that. With respect to that in particular, with respect to you know, Your Honor's question of how do you handle that when you have a district like 19 that changed fairly substantially in terms of its boundaries, and there is what Your Honor characterizes as a notable change, my word, not yours, with concept in the minority representation. And I guess all I can do, Your Honor, is point you back to the standard this court has applied previously with respect to analyzing claims of racial impact that would render a map potentially invalid. And the standard has been, does the challenge, practice, or structure suggest that plaintiffs do not have an equal opportunity to participate in the political processes and to elect candidates of their choice? I recognize that that is a somewhat unsatisfying standard on this record, but that's.
Is it fair? Is that the right analysis to look at a district in isolation, or is there a higher threshold for a plaintiff or a challenger to demonstrate a pattern beyond a sort of a single district? Because it strikes me that, you know, when you start pulling, you know, maybe like a magician's hat, when you pull a handkerchief on one district, you might be unwinding a whole lot of rationale and reasoning that went into the map as a whole in all 125 districts. How do we analyze these sort of district-specific challenges?
Justice Wall, absolutely. I think that's an issue the court has wrestled with in its past cases and must. I haven't said it yet today. I presume it's obvious to everybody in the room, not just here, but what you say is absolutely correct. I mean, the difficulty that the legislature always faces every time they reapportion for whatever purpose is that they must draw a complete map. And that map must fill every inch of the territory of the state of Kansas, and it must not spill outside the boundaries of the state of Kansas. And if it fails to do that, then the map has legal problems, as it did, I already suggested, in 1963 when they omitted the city of Leawood, just to illustrate the point. There is a ripple effect to every decision, especially given that there are boundaries that would cause properly this court to invalidate a reapportionment, such as malapportionment, such as a failure to get substantially equal population district to district. We know that is a hard test that is required by the U.S. Constitution, and this court has applied. So you're absolutely correct. It's very difficult in looking at these single district challenges, which understandably, by the folks who are distressed by those districts, understandably, they're looking at it through that lens, local communities lens or local districts lens. The legislature didn't have that luxury. They have to look at it in terms of how it fits the entire picture and how a decision in this illustration, and I don't know that this is the case, but a decision in Northwest Douglas County and Northeast Shawnee County could literally affect a district in Southeast Kansas or even north and west of Wichita. That's one of the difficulties in the puzzle.
other questions?
Thank you, Your Honor.
Good morning, Chief Justice Lukert, justices, may it please the court. I'll reintroduce myself. It's been such a long time. I'm Mark Johnson. I'm a lawyer practicing in Kansas City, and I'm here with my co-counsel, Steve McAllister, Betsy Lassiter, and Senator Holland. stand for a second, please, is with us today, and I'm here on his behalf. My presentation will not nearly be as broad as the Attorney General's, because my task is different. I am here today to talk about two Senate districts, Senate Districts 3 and 9, essentially near Lawrence, Leavenworth County, Johnson County, and the like. Senator Holland has represented the 3rd Senate District since 2009. He's been elected 4 times to represent that district. District 9 is represented by Senator Beverly Gossage, who was elected for the first time in 2020. The changes in the 2 districts, which resulted from the process, and I'm going to use the word process advisedly rather than procedure, because I think you need to look at the process that led to the district lines that are at issue here, rather than simply the procedure by which the legislation was passed. It's a broader question. The redrawing of these lines has resulted in no less than 4% of the state's population of 3 million being represented by senators they didn't elect. More than 100,000 Kansans, because of the way these lines were changed by the legislature, are now represented by senators they did not elect.
How does that work when the new lines don't take place until the new election? Or am I missing? What am I missing? Is that because of the way the Senate is staggered from the House? Is that what
It
you're
has a lot to
describing?
do with that. Of course, we won't have elections for the Senate for another 2 years or so.
And this is a genuine question. I don't know the
I
answer.
understand.
Does that mean that because the new lines take effect this year, that what you're saying is that there are people who had their representatives switched as a matter of these maps because of where they live? Is that what you're saying?
It's a confusing issue. I will allow that, Justice Stegall. Perhaps informally, they're being represented by the senators they didn't elect. Perhaps formally, they're being represented by the Senate. The key, though, is that the lines have been changed. And if this court, in its wisdom, decides to allow those lines to remain in effect, they are effective. You decide this week or next week that the district, even though the next election isn't another 2
Does that mean that
years away.
certain senators live outside their districts for the next 2 years? Is that what you're saying?
Well, certainly it's a possibility. Not in this situation, or perhaps is it in this situation? As I see the map that the legislature has issued, Senator Holland's residence is no longer in District 3 as redrawn. It's in District 9. Is he representing the old 3rd district or the new 3rd district? It's a conundrum, no question about it. And that's one of the problems with the process. The Attorney General asks you to look at the result. I ask you to look farther back in time. Go back to the middle of last year, middle of 2021, and follow the process through, and then look at the result. And I think, unfortunately, the result was predestined. Decision was made to draw the district lines in such a way, regardless of the input from the citizens of Kansas, regardless of the input from anybody else involved in the process, other than the majority in the legislature running the redistricting process. You go back to last summer when the listening tour was announced. The Democrats had no role whatsoever in that. They knew nothing about it until it was announced fully formed. Until the entire schedule was announced, the Democrats had no idea that it was going to happen. Fast forward after the listening process. And by the way, let me make one point there with respect to this listening tour. It's supposed to allow the citizens of Kansas an opportunity to tell their legislators, the redistricting committees, how they would like the redistricting to go. 14 of those meetings took place in person, 4 virtually. I'm sorry to say, if you look at the photograph that's in our brief, you can see how those citizens were treated.
But let
By
me
the
interrupt,
majority.
Council. What can we do about that? I mean, we're just a court. We can't make these guys play nice with each other. We can't tell them to put down their phones. Can't tell them to listen. So, I mean, I understand, well, you know, might believe they were treated discourteously. That I can understand. I just don't see how that translates into anything we can do from our spot.
Justice Biles, it does translate into something that you can do, and that is grant the relief that we seek, and that is to send the map back, instructing the legislature to do it right this time.
But on what grounds? I mean, where is that rooted in law? That the legislators can't look at their phones during the listening tour?
Well, it doesn't, of course, the law doesn't say that, but the legislature is now trying to say we don't need to behave well in the listening tour because we didn't have to conduct a listening tour, we just did it. The grounds I think you would look at is something that the court has alluded to in the cases that it's previously handled concerning the validity of the new districts. And that is, if you see that the districts lack compactness, if you see lacked contiguousness, that raises, as Justice Biles indicated, an inference, an implication, a question of gerrymandering. But if the legislature provides an explanation, a justification for the lines that it draws, even though they may appear to be non-compact or non-contiguous, then that's good enough. The problem here was one of process. In all of the 6 cases in which this court has previously dealt with the validity of districting lines, the legislature issued a report which it talked about how it made the decisions that it did. If you look at each of those cases, they talk about the special report, the legislative report. I referred to one of them in our brief. Footnote 1, the only footnote in our brief refers to a report that the redistricting committee issued in 2002 that comprehensively discussed the process, not the procedure, but the process that it followed, starting with the listening tour, starting with no fewer than five full committee meetings at which legislative maps were discussed before anything was cast in concrete, before any final proposal was made to the legislature. No such meeting of that type occurred in the 2022 redistricting process. The map was issued on March the 14th of this year, fully formed, fully drawn. The Democratic members of the Senate Redistricting Committee did not know that the map had been drawn, did not know what the map lines consisted of, did not know that when they arrived at the legislature that day, they would be receiving a map handed out by the Republican majority. So it's a process issue.
What if they comply with that process as you envision it, and the end product is the same map?
Well, I think at least with respect to districts 3 and 9, there would continue to be a problem. But with all respect, Justice Wall, that's a theoretical question because they didn't follow the process. They didn't follow an honest, open, transparent process. In your cases in which you've discussed the vetting of the maps for validity in the past, in at least one of those cases, it was mentioned that there was no implication that any of the legislative meetings or actions took place in secret, took place behind closed doors. And that was, in that case, mentioned as a positive, mentioned as something that argued for the validity of the maps. This process was different. This process was secret. And it seems to me that if in one case, court speaks positively about an open process, and here you have a case in which the process was not open, was not transparent, then that certainly has to be taken into consideration, just as the court took an open process into consideration.
It just seems to me that analytical process that the Attorney General laid out is the one that I see in the case law. Is you look at procedure, you look at validity. And then for validity, you look at procedure and then the substantive nature. There's nothing in the Constitution, there's no requirement, listen, to be nice, to even be transparent. I mean, I hate that word, public about it. So it seems to me that on the procedural step, which is the one you're trying to push back on, it seems like we're really just, we ought to be just, the only way we have any kind of standard is to just say this bill did in fact hit all the steps to become law. Now, I understand your argument that says this looks really bad and this, so now we ought to look deeper on the substantive side for mischief. And we can just, but I don't see how you, and your argument is about validating this bill because the procedure was wrong. Sorry, I don't see a legal standard to apply other than what are the steps to make a bill law.
Justice Biles, that's not the limit of the standard that I believe you should apply. I'm talking about the process. You should also look at the result of the process.
And I understand that argument. I just don't, I'm just telling you, I don't see that the first step isn't met. The procedural part of this is
well,
it is a law, I mean, or it's about to, it made all the steps.
Of course, it doesn't violate the single subject rule. It was properly introduced. It has an enabling clause. So if you want to look at it from the point of view of did it follow the steps for the adoption of a piece of legislation, it did. We are not contesting that at all. What we are contesting is the substance of the legislation as a result of a flawed process.
Aren't you asking us to presume that the only time the legislature listened to the public was during these stops? And what is your basis for such a presumption?
Justice Wilson, I'm not asking you to presume that the legislators didn't talk to their constituents outside of this listening tour, outside of other opportunities that might have been afforded to individuals to comment on the process. What I'm asking you is to take into consideration the fact that we can't speculate about that. We can't speculate about what the legislators may or may not have done because there is nothing in the record about that. We perhaps would have had that. And in fact, if you go back and look at the 2002 report that the legislature that the redistricting committees issued in January, along with their recommendation as to which maps, Congressional, House, Senate, and Board of Education, which maps to adopt. The redistricting committee talked about the process, talked about all of the maps that it considered, and then provided recommendations as to which to adopt, and also afforded the minority the opportunity, which the Democratic minority took advantage of, to provide their objections, their comments on the maps. But we don't have something like that here. We don't know what the redistricting committee did. All we know is that there was this listening tour. And on March 14th, a map magically appeared. Don't know what else went into the process. And in the absence of having some understanding and some participation from everybody who's supposed to be involved in the process, which includes the Democratic members of the redistricting committees, how can we say that that is a legitimate process? And if you look at the results of that process, which in this case, we're looking at districts 3 and 9, you can see changes that have no seeming explanation. Why was District 9 taken from a truly compact, almost a square of northwestern Johnson County and blown up like a balloon, which it was. It was a nice compact portion of Johnson County and was blown into a district that now occupies parts of 4 counties. And another interesting point about that is that District 9 had 10,000 too many people. Senate districts are supposed to have about 73,447 is the number that I remember. So let's say 73,500 people. At the time, this goes back, this is from the 2020 census, District 9 had over 83,000 people living in it. By traditional notions of redistricting, you don't expand that district geographically, you shrink it. That's what was done, for example, with Senator Corson's district. He represents the 7th Senate district, which is northeastern Johnson County. There were too many people in his district, and what happened in his district? It shrank. Why did District 9 explode? Well, if you look at what happened with District 3, which had traditionally been sort of the western half of Leavenworth County and the eastern half of Douglas County, it was picked up and moved miles to the point where only 2% of the people who now live in District 3 lived in District 3 before the lines were redrawn. So that's where I get this, I guess you say, mathematical result that over 100,000 people who are now in different districts than they were before.
Council, I don't know how familiar are with the substance of the Enray Stephan decision from the court, which is the 1992 case. That one's involving the House district, but it struck me that that case really pushes against the arguments that you begin to make at page 10 brief about not meeting the guidelines and the compactness and that particular case was when David Miller was objecting to Eudora being moved.
Right.
Just to help with the reference there. And it just seems to me the court went through, I actually kind of thought your brief looked like you looked at that case and used those elements, except that the case rules against you on each one of those elements. And I guess what I'm saying is I have a hard time getting past that case in order the validity to your arguments. So I'm just giving you the opportunity to explain to me why I'm wrong about that.
Okay. Well, in that case, there's a good example of the committee, the redistricting committee, explaining the decisions that it made. 3 pages of that decision talk about the report from the redistricting committee with respect to difficult decisions that have to be made. And clearly in redistricting, difficult decisions have to be made all the time. No, as the Attorney General indicated, there are always going to be people who are happy with the result. There are always going to be office holders who think they've been shortchanged. But when the legislature explains why certain decisions were made, and it did that in that case, then the court, I think, can be satisfied. In fact, this is the case in which the court makes the comment that there's no evidence that the legislative meetings or actions were conducted in secret. And they view that by, in reading the case, as a positive. But in this situation, it's entirely to the contrary. Things were done in secret. And we don't.
Where do we get a legal standard that invalidates legislation because the legislature didn't show its work? Where does it come from? It's not in the Constitution. I can't find it, in any case law here. And that really seems, taking best practice aside, where do we draw from to make, what's our source of law to be able to make the rule that they, have to show their work?
Well, first source of law is, as the Attorney General, at least I thought indicated in their brief, that you have to look at the substantive validity of the legislation, and that there are 3 elements to that: population, compliance with the Voting Rights Act, and, at least I thought until today, when Justice Stegall, you pushed the Attorney General on that, he seems to have walked away from the need to show compactness and contiguousness and not breaking up municipal or county lines, not putting incumbents against each other. He seems to have walked away from that by saying that's not included in the constitutional test that you should apply. I'm not walking away from that at all. I think you should look at those factors. And by saying that there are only 4 factors in the guidelines, that's a bit of that's a little misleading. Yes,
just quick interruption.
Sure.
Which part of the Constitution are we deriving those principles from, in your view?
I think you're deriving them from the right that all Kansans have to have an effective exercise of their vote. You asked, I believe, about how could the legislature discriminate against voters other than by placing them in districts they don't want to be in. There are plenty of ways, at least in my opinion, that the legislature can, and I'm sorry to say, has discriminated in the past. Voter registration laws, which have been found to be unconstitutional. Limitations on advance voting, limitations on access to ballot drop boxes, things like that. Of course, that's not involved in this case at all, but there are ways in which the legislature can take action.
So is it the right to vote clause that you look to?
Yes, yeah, I mean,
in the state constitution?
Yeah, it's important to say right, not just right to vote, but right to have one's vote counted, which is an expression of one's right to.
But let me
have an
probe
effective
that a little
right to
bit
vote.
further.
Absolutely.
What does it mean to, so if we if we read into the right to vote clause, a right to have a quote, as you use the word, effective vote, what does that mean? How would we know whether someone exercised an effective right to vote versus an ineffective right to vote? If I'm a member of the
Question.
Green Party or the Libertarian Party, for example, I might think, boy, my votes have been ineffective my entire
Well, and
life.
I've had the privilege to represent both of those parties over time.
So can you articulate a legal standard which would enable a court to differentiate between, I mean, we have two people, they have each cast votes and
Yes.
each vote was counted.
Yes.
How do we know when one is effective and one is ineffective?
Well, in your hypothetical, one of the factors of the effective right to vote, you are assuming that's the vote, that the vote is counted. Goodness gracious, how many times have we had votes not counted?
Right.
But
Let's assume for
that's-
purpose of the
let's
question
assume
that they're both counted.
their vote counted. That they did not have to utilize what many people would call unreasonable, did not have to go to unreasonable efforts.
Let's just presume again, for purpose of my question, that they went through identical efforts. There's
Well,
no
in-
distinction between the mechanism of the vote or the fact that it was counted.
If someone votes and the vote is counted and they didn't have to go through, as you know, if you go back to Marion County case, undue burdens to vote, I think that's an effective right to vote.
And isn't that true here in versus District 3 and District 9?
Well,
I mean, that's my problem with the argument is I don't understand how you make the leap to ineffectiveness based on sort of vague gerrymandering claim.
But you took the word right out of my mouth, Justice Stiegel, that at some point you do get into gerrymandering by the drawing of district lines. And so someone would say, well, my effective right to vote includes the ability to elect representatives of my choice.
Right. And
Not
that
the
lingo,
assurance that
that
you'll be able
lingo
to
is
elect them.
in the case law. But again, I ask my Green Party or Libertarian Party on behalf of my friends in those parties,
Of course.
they, how does that work? Have they been denied the right to elect their preferred candidate their entire lives?
No, they just simply don't have the number of votes necessary.
And why isn't that always the case? No matter which person is on the losing end of an election, you just didn't get to 50% plus one.
Right. Well, knowing that this really has nothing to do with redistricting, with the exception of what side of the line one is placed, the effective right to vote is as you've described it.
So are you conceding then that the District 3 and 9 lines do not violate the right to vote because they provide an effective right to vote?
I can't concede that. What I can concede is that, assuming that the county election officials run the elections as they should, everybody who wants to vote and is a qualified voter will be able to vote.
I guess last follow-up, is there any other clause of the Constitution that you would look to ground your argument that these lines between 3 and 9 are invalid?
Of the Kansas Constitution, no.
Would your answer be different if it wasn't just 3 and 9, but as Justice Wall mentioned, there was a pattern, and the pattern was to draw, you see a pattern of drawing incumbents out of their former district in a pattern based on political affiliation?
I would.
And on what ground?
Well, on the grounds that the voters would be able to say, I can't elect the candidate I wish to elect because he or she no longer lives in my district. Similarly, I suppose one could also complain about placing incumbents in the same district, which, by the way, is what's happened here. According to the map, Senator Holland and Senator Gossage now both reside in District 9. And if one of them wants to remain in the Senate, or actually both of them want to remain in the Senate after 2024, they'll have to run against each other, assuming they could get their party's nomination. Like so.
That,
What you're talking, I believe, is part and parcel of the gerrymandering process, where you not only have voters placed in certain districts based on partisan or, or political grounds, but you also have either incumbents or potential candidates placed in districts where they can't be elected because of the way the new district, or they have to run in a district with which they're completely unfamiliar.
but of course, a candidate, we're talking about voter rights here, not a candidate's
Understood.
right. So what's implicated by turning to this hypothetical where it's done across the whole state in the map drawing, where one party's political incumbent is, the line is just drawn so that they're in a different district. What right is implicated?
From the
The
voters,
Yes.
from the voters' point of view, I think the right to vote effectively is implicated
How?
because they are not allowed to vote for the candidate they want to support.
So there's a
and the only
difference
reason
when it
they can't
happens
is-
in a pattern as opposed to
I'm
an
sorry.
isolated interest? If it does it make a difference then that it happened in a pattern as opposed to an isolated district, like what happened with 3 and 9 here?
Most of the time, Justice Standards, I would agree with you that if there's a pattern, then that would be demonstrative, that would be probative of gerrymandering. But where you have something like that in isolation, and in fact, with this redistricting, as I remember, there are 2 sets of incumbents that are potentially matched against each other. One set in central Kansas, one set, of course, in eastern Kansas. But in the absence of knowing why the lines were drawn for districts 3 and 9 in the way that they were, and we don't know why because the legislature hasn't educated us on that, then certainly an inference can be drawn that that the lines were drawn in such a way to match those incumbents against each other, which is something that the guidelines say shouldn't happen.
So let's say that there is direct evidence that the reason that the legislature did that was based on partisanship. Don't have in this case, but let's say it was. What would be the voter's right that was, how would the voter be deprived of a constitutional or statutory substantive right?
Well, if the voter, let's say, is a Democrat, and the lines are drawn in such a way that no Democrat can win in that district. I mean, theoretically, yes, they can win, but most people are pretty consistent in how they vote. From a practical point of view, a Democrat would not have a chance to win in that district. That is emblematic of partisan gerrymandering, which in my opinion, denies the individual voter the right to vote for and elect candidates of their choosing.
So would it deny them equal protection?
Yes, it's an equal protection issue because I mean, what you have is 2 individuals similarly situated, both voting. One has an opportunity to elect a candidate of his or her choosing, and the other doesn't.
So do members of the 2 major political parties in the United States, Republicans and Democrats, do those individuals have greater constitutional rights
No, they
than
don't.
members of minority parties?
No, Justice Siegel, of course they don't. And in fact, in American history, we have had situations where parties that started out as minority parties very quickly became majority parties. Look at the Republicans.
Well, I understood you to argue that if there's a district in which you used the party Democrat as your example, in which that party was
For
not
purposes of
practically
illustration.
able to win, that a member of that party would have their constitutional rights infringed upon. And I'm just asking, is that the same for members of all different political parties? Because logically, I don't understand how that's even possible. And I assume you understand the nature of my question.
I understand, but I believe the assumption, at least I understood the assumption, Justice Standridge's question, was that the reason that the lines were drawn in such a way was partisan. If, to sort of extend your hypothetical, the legislature decided they didn't want to have, they didn't want to afford candidates of the Green Party any opportunity to win. And they drew district lines in such a way that all adherents to the Green Party were placed in a district where their candidate had no chance of winning. They could say, yes, that's a violation of my constitutional, I mean, my right to vote effectively. And that is purely hypothetical, of course.
But what makes it ineffective in that scenario, it almost seems like you're suggesting that citizens of our state have a due process interest in the maps as they existed before reappropriation. And that, I don't think there's any basis for that sort of argument, is there? Because it's only
If you're
now
talking about
that
constitutional due process, no. I'm using the term process not in the way that perhaps we lawyers often use it when we talk about due process. I'm talking about the process of how the legislature went about.
I understand
the
that, yes, but what I think what Justice Dandridge and Justice Stegall were asking, and maybe I didn't quite understand your answer, is what is it beyond proportionality that implicates the right to vote in an equal protection analysis? And I was just speculating, well, maybe you're suggesting that there's some due process right in the map as it existed before reapportionment, but how else do you fit political affiliation into the right to vote equal protection bucket, I guess?
Well, of
I'm
course.
sorry, it sounds like I'm repeating the same question.
No,
so
you
I don't
no.
understand the answer.
Oh, Justice Wall, I understand. In talking about districts 3 and 9, as I am, I'm not approaching this from a partisan point of view. That, I suppose, is for this afternoon's discussion. But just responding to questions raised by Justice Stegall and Justice Standridge that raised the issue of partisanship, I felt I needed to address it. But to get back to where I think to get back to the question that's before the court, in this situation, the flaws in the process led to 2 districts being drawn in such a way that they simply do not comport rules with the guidelines that the legislature has said following, or that it would follow.
Are you reading the guidelines into the word valid?
Yes.
Okay, so that helps me because I was
Okay.
earlier asking
No,
what clause.
I understand the Attorney General took the position of the contrary.
Right, but earlier I asked you what clause of the Constitution you were ceding, you were drawing those principles from, and we had that discussion about the right to vote and so on. But now I understand what you're saying is you're actually drawing those requirements from the guidelines, which you believe are subsumed within the word valid.
Yes, and in fact, the The court has indicated in the past that these sort of traditional notions of redistricting that are in the guidelines, section 4 of the guidelines, the court has in the past said that they should be used in this process. In the In re Stovall case, 273 Kansas 715, the court said, and this is a direct quote, the United States Supreme Court has identified a number of legislative policies which, if consistently applied, might justify a deviation from an ideal district population. Those policies include making districts compact, respecting municipal boundaries, preserving the cores of prior districts, and avoiding contests between incumbent representatives. So the court has already said that what might be, at first blush, a constitutional problem, in other words, districts that have unequal populations, can be validly explained by reference to these traditional notions of redistricting. The problem, of course, here is that we don't have anything like that. We don't have a record. We don't have a report from the legislature that they took these factors into account.
So are you saying then inversely, if we don't know exactly why they did what they did, we must presume they did it for inappropriate reasons?
Justice Wilson, I don't think I'm going that far. And if you get that from me, I'm not. What I'm saying is that where you have circumstances such as we have, need to look for some justification, and this is then to use the word the court has used, a justification for the decisions that the legislature appears to have made.
Is there any presumption of regularity?
That I don't know. The answer may well be yes, but the thing is here, we don't have that. We have a process that was conducted.
Don't you begin with the presumption that must be rebutted?
Well, even for the sake of argument, if you do, we believe what is in the record rebuts that presumption. The listening tour that, by all indications, made no difference in how the lines were drawn.
So you concede there is a presumption of regularity?
I'm not going to, I would not concede that there's a presumption of regularity. I'm going to say that if there is, that presumption has been rebutted in this situation, in this case.
I have one, just tying up one loose end from earlier. Way back at the beginning of your argument, we had talked about the moving of the 100,000 voters or what
Right.
have you. And I double checked the bill, and it looks to me like in section 4 of the legislation, the legislature indicated that the new Senate boundaries would not be effective until 2024, which would suggest to me that old District 3 will continue for 2 more years. Does that impact your argument at all?
Well, it's certainly something that should be taken into consideration, but I don't believe that it results changing the argument that I have.
At a minimum, it would relieve. At a minimum, it would dispense with the claim that there are voters who now don't have a senator, because the voters, the constituency who elected Senator Holland will continue to be represented by him for the next 2 years.
Well, certainly everybody will continue to have a senator. If I said that there are people who don't have a senator, I certainly didn't mean to imply that or to say that. Perhaps another way of looking at this is, again, from the voter's point of view. One of the guidelines is to draw districts that voters understand. Don't know whether voters who are in these districts understand why these changes have been made, because it hasn't enlightened us as to why those changes. Thank you so
Council.
much for your attention. Believe it or not, I've enjoyed this.
Council, at this time, we'll take a 10-minute break and resume at 5 minutes till the hour. We'll be in recess.
The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess now sitting.
Please be seated. Attorney General.
My intention is to offer 5 points that I jotted down that I thought would be perhaps helpful, and then be glad to respond to any further questions the court may have. As a prefatory matter, Your Honor, I might say that I, just on a personal level, I do have a real amount of empathy for, in this case, happens to be Senator Holland, for an incumbent who is placed in a situation they don't wish to be in as a result of redistricting. This is the third round of legislative redistricting through which I have lived in my professional life. The first was in 2002, where my own Senate district was redrawn to grow from 6 counties to all or part of 9, and stretched. It was a solid 2-hour drive at the speed limit from the southwest corner to the northeast corner, from Cedarvale to Williamsburg, although I was not placed in a district with other incumbents. That did occur in that redistricting, it just didn't happen to me. Then in 2012, of course, I was no longer in the legislature, but had occasion to provide the state a defense in the federal lawsuit that resulted, and there were incumbents placed together in that as well. There is no disproportionate number of incumbents together here compared with the last 2 rounds. It's within about 1 either way. And I recall having the occasion, unfortunately, unknowingly, to call an incumbent who had been placed in a district with another who didn't know that yet. I didn't realize I was going to be informing them, and I recall the distress. And so my only point in saying that is, it is a difficult circumstance, but it is one that this court has addressed in the past and has consistently said does not invalidate the state legislative maps as they've been enacted. The 5 points I jotted down were these. First, with respect to Justice Steagall's line of questioning, I think that he and my friend got to agreement on that, but I can say that it's only once every 20 years that, because of the staggered nature of the Senate 4-district terms, that you're in this circumstance of you have redistricting in the 02 year, but the new election doesn't happen until the 04 year. That did happen in 2002. And at least in that case, and I presume here, the senators just continued to represent their current district until they filed as a candidate for the new district, and voters decided whether to hire them in the new district. There was no sort of break in service. There was nobody left unrepresented.
Would you agree with my reading of section 4 of the bill that would suggest that I'll call them the old districts, the old Senate districts, will actually continue for 2 more years?
Yes, I would. And in fact, that was, to the extent it's relevant, may not be, but that was my experience when that happened to me in 2002. I viewed it as an advantage and used 2 years to get to know my new constituents before they became my constituents and I was running with them. Second point, actually I've already touched on, which is incumbents together. I'll not belabor that. The third point, I'll not belabor the guidelines either, but I do want to just emphasize our position, which we discussed before. The guidelines are not law. They don't bind this court. They are guidelines for the legislature. And this isn't the first time that guidelines have been argued as a reason for this court to invalidate maps. I believe that occurred in the 1989 maps, where a Representative Fry, who I do not know, but who was described in the opinion, as representing at least a portion of Rice County, brought an argument to this court suggesting maps ought to be invalidated because of the guidelines, and this court declined that invitation then, as I would suggest ought to be done now. Fourth, with respect to the listening tour and the process more generally, if the court has concerns or questions, I will, to the extent I can't answer them. I would only suggest, as Justice Biles did, that this issue has been before the court before. It was in the 92 maps where then I believe it was Eudora Chamber of Commerce President David Miller made very similar arguments, and this court rejected them. And I would add, I can only surmise, but I suspect it's not mere coincidence that involved a similar piece of territory of earth as the matter in front of you today. And this goes back to my discussion with Justice Wall when I was first at the podium. The geographical reality is we have a large and growing city in Lawrence. We have a large and growing group of cities in the Johnson County suburbs. We have a large city in Wyandotte County, and we have a relatively large city in Leavenworth. And this particular piece of territory gets squeezed. That's just a reality. And it's one of the things legislators have to deal with as they try to figure out the ripple effects of making the decisions they do. And the final point I would just make, Your Honors, and then be glad to either sit down or answer whatever further questions the court has. I of course recognize the court has to make its decision on the substantive merits of the suit, and I'm not suggesting otherwise, but I feel like I'd be remiss if I didn't remind the court of what you already know, which is the timelines we are operating under here. The filing deadline, of course, you have to have new maps before you can have a filing deadline. The filing deadline by statute was set for noon on June 1st. By operation of law, because we've missed the May 10th deadline, that deadline has already been pushed back for district-based filings, including the ones at issue here, to June 10th. It's my understanding after consultation with the Secretary of State's office that June 15th is something of a hard deadline in terms of they have to know in order to prepare the military ballots that are federally required and get them in the mail with the proper federal timelines in time for the August 2 primary. And so as the court decides what to do, I would just urge the court to be mindful of those deadlines and also of the deadlines in Article 10, should the court not approve validity in terms of going back to the legislature. They have a certain time to respond. We must petition or bring the matter back to you, and you have a certain time. With that, Madam Chief Justice, I would either stand for further questions or stand down.
Are there other questions? Thank you.
Thank you.
Thank you to both counsel and to all those who commented and otherwise brought their concerns to the court in this matter. As was referenced earlier, it is an unusual process in this matter, but we appreciate those who became involved and provided us with those comments, as well as the arguments and briefing. With that, the court will be in recess until 1:30 this afternoon.